The question of whether a woman who is staying in a women's refuge is entitled to be treated as homeless and rehoused by a local authority still comes up from time to time. Women who apply to local authorities for accommodation as homeless persons while staying in women's refuges are sometimes wrongly advised by council staff that they're not entitled to assistance. The reason given for this is that they're living in a refuge, so they're not homeless. The legal position is set out in Section 1751 of the Housing Act 1996, which provides that a person is homeless if she has no accommodation available for her occupation. Section 1753 provides that a person shall not be treated as having accommodation available to them unless it's accommodation which it would be reasonable for them to continue to occupy. It should go without saying that the accommodation which the woman left because of domestic violence can't be treated as reasonable for her to continue to occupy. If it does need saying, then Section 177 specifically provides that it is not reasonable for someone to continue to occupy accommodation where they would be at risk of domestic violence. This leaves the question of whether a refuge, where the woman won't be at risk of domestic violence, can be treated as accommodation such that she is not entitled to be treated as homeless and accommodated by a local authority. This question came up in the case of Birmingham City Council v Ali and others, and Moran versus Manchester City Council in 2009, when the Supreme Court held that refuge accommodation should generally not be treated as reasonable for a woman to continue to occupy for more than a short time. This means that the woman should be treated as homeless by a local authority. The Supreme Court considered that there were a number of reasons why a women's refuge shouldn't be treated as reasonable to continue to occupy. These include 1. It is usually never intended to be anything other than a temporary haven which someone will only stay in on an emergency basis. 2. The rules required to maintain secrecy and protect residents of refuges from violent partners, such as not having guests or telling people where you're staying, are incompatible with what is considered to be a home. 3. Refuges are unlikely to be appropriate places for children to live in. As a result of this judgment, the law on whether refuges can be treated as accommodation and residents treated as homeless should be clearly understood, and anyone receiving advice to the effect that they're not entitled to be treated as homeless in this situation should challenge the decision.